Welcome to the VACo County Pulse Legislative Series. This legislative series of the Pulse is focused on the issues that impact Virginia's counties. This series is developed by the Virginia Association of Counties and shares with our viewers the pulse of Virginia county governments. I'm Dean Lynch, VACo Executive Director, and your host today. I'm excited to have VACo Director of Government Relations, Chris McDonald, with me for this episode on recently passed marijuana legislation. As many of you know, Virginia became the first state in the South to legalize marijuana when the General Assembly passed it during the 2021 session. Governor Northam then amended the bill to make marijuana legal beginning July 1, 2021. Chris McDonald has been following this issue for VACo. Chris, thank you for being with us today.
Morning, Dean. Thanks for having me. Looking forward to talking shop and really diving into these bills a little bit with you.
Chris, marijuana is being legalized. What does that actually mean? Is everyone free to buy, sell, and do whatever they want starting this July?
Simple answer, Dean, is not really. While the headlines that you see in the last couple of weeks have all proclaimed marijuana legalized, it's really not that simple. What we're really talking about here with these two bills, HB 2312 and SB 1406, at least for now, we're talking about simple possession of marijuana as well as home growing. So beginning July 1, 2021, it's not really a free-for-all. What we're looking at is that it will be legal for adults here in Virginia to possess up to 1 ounce of marijuana or the equivalent of 1 ounce in marijuana products. Adults who are caught with more than an ounce but less than a pound will still face a $25 fine. Adults found with more than a pound can actually still be charged with a felony punishable by 1 in 10 years in prison, as well as a fine of up to $250,000. Minors, of course, still are prohibited from possession. Individuals under the age of 21 who are caught will face a fine as well as be required to undergo substance abuse treatment and education. And then finally, when it actually comes to even consuming marijuana once it's legal coming this July, that comes with restrictions as well. The legislation in question today is very clear that no person can consume or even offer marijuana or marijuana products to another in public places. So this, of course, includes sidewalks, public parks, parking lots, government property, school grounds, etc. So it's a lot more limited than just a wholesale marijuana legalized in the Commonwealth.
Chris, marijuana, it's a big business and means lots of money. So are we going to start seeing stores open up on every corner of Virginia?
Definitely not. That is a far cry from really what we're looking at happening here in the next couple of years. With these bills, what we're looking at is twofold. First is the legalization piece, which I just mentioned, and then the second is the commercialization piece, the retail stores. The legislation in question does provide a roadmap for marijuana in retail stores, so providing that legal and regulatory framework for retail stores, but that is all still delayed until 2024. Opening a full-scale legalized retail market is something that's going to take a lot of thought, planning, and time. So the legislature decided to not really rush this piece and instead delay it for another 3 years. This will hopefully give enough time to the Commonwealth to set up the Virginia Cannabis Control Authority. That'll be the governing body that will regulate the possession, sale, et cetera, of marijuana. But in the ensuing months and years, this authority will actually continue to examine how to best roll out commercialization and develop a regulatory path forward. So again, right now, when we talk about marijuana legalization, we're really just looking at simple possession and letting adults grow their own plants.
So if retail stores won't exist until 2024, how are people actually going to acquire marijuana?
It's a great question, and one that has caused a lot of questions from the General Assembly and some furrowed brows. But really what we're looking at right now is there are two key ways that this legislation contemplates for actually acquiring marijuana and marijuana products. First, as I've mentioned before, this legislation does allow adults to actually grow and harvest their own plants. For those maybe following along at home, this is under section 4.1-1101 of this new legislation, and it allows a person of 21 years of age or older to actually grow up to 4 marijuana plants for personal use at their place of residence. Now, there's a bit of a caveat here, or a bit of limitation here, that at no point shall a household contain any more than 4 marijuana plants. So for the purposes of this section, a household means individuals, whether they're related or not, who actually cohabitate in the same house. So while each adult in a household may technically be allowed to grow up to 4 plants, there's also that household limit of 4 plants. So that prohibits married couples, family members, roommates, friends from growing kind of a whole garden or forest of plants. And even when we talk about growing your own plants, there are additional requirements that we should all keep in mind. First, marijuana plants may not be visible from any public way without the use of aircraft or binoculars. So if you're planning on putting a few marijuana plants in your front yard along your row of scarlet begonias, you're out of luck. You cannot do that. Secondly, the grower has to take really a lot of precautions to make sure that there's no unauthorized access by minors. So if you've got a greenhouse or a garden, you got to make sure it's padlocked and not accessible to your own children or even the neighborhood kids. Third, you got to tag your plants. This legislation requires that each plant that an adult is legally growing have a legible tag on it that actually has their name, driver's license or ID number, and a notation that affirms that the plant is being used for personal use. And then finally, you can't grow any homegrown marijuana plants for the production of concentrates. So this kind of avoids the idea of kind of getting more out of your plants or even infringing upon other markets.
So, Chris, what happens if you violate these rules? What's to stop someone from growing a dozen plants?
Well, that kind of gets back to what I was saying earlier, that while this legislation does legalize possession and growing your old plants, it is really limited in what it allows. If you're found to be growing more than 4 plants, there's actually an escalating scale of punishments that are very clearly laid out in code. If you're following along, this is section 4.1-1101, subsection D. If you're growing more than 4 plants but less than 10, there's a civil penalty of $250 for the first offense. There's a class 3 misdemeanor for the second offense, and then a class 2 misdemeanor for a third and any subsequent offense. If you're growing more than 10 plants but fewer than 49, it's actually a class 1 misdemeanor. And if you have more than 49 plants but less than 100, it's a class 6 felony. And finally, if you're growing a whole forest of this, so possession of more than 100 plants, it's a felony punishable by a term of imprisonment of 1 to 10 years and a fine of no more than $250,000. And then beyond the penalties of having just too many plants, if an individual is found to be growing marijuana outside of the confines of this section, so not really growing it by the letter of the law, they're automatically guilty of a class 6 felony.
All right, that's home growing, as I understand. You said there was a second way to acquire legal marijuana. How is that?
That's correct. And this one's a little more puzzling when you think about it all the way through. The second way that the legislation legalizes, I guess, the procurement, for lack of better words, of marijuana for adults is through what they call adult sharing, or what we would just call gifting. So under section 4.1-1101.1, this legislation permits adults 21 years of age or older to gift marijuana to another adult 21 years of age or older without remuneration. So giving it to a friend. No sales are allowed whatsoever under this legislation. I'll quickly note there's another section in this bill, section 4.1-1103, that really lays out the prohibition on these sales. There it notes that any person who is not licensed to sell but does sell is guilty of a class 2 misdemeanor, and all subsequent offenses shall constitute class 1 misdemeanors. But it does contemplate that adults can gift to one another. One interesting thing I'll note here is that Virginia did something kind of interesting related to, or I guess addressing what other legalized states have seen. And that is expressly forbidding gifting marijuana as a part of another commercial transaction. In some states that have legalized marijuana, what we've seen kind of arise is that businesses or individuals can upcharge for certain products and then include a free gift of marijuana. So say you're sitting at home on a Friday night and you order a pizza. They may charge you $75 for that pizza, but then they'll throw in a free gift of marijuana as well. This bill outright forbids that. They really wanted to ensure that this was not kind of the loophole that we've seen in other states.
Chris, let's talk revenue for just a moment. What can you tell us about the tax levy and revenue piece of the bill?
You know, Dean, outside of the criminal justice and social equity pieces of this bill, the tax and revenue piece of this legislation has been one of the biggest areas of discussion and frankly support during the last General Assembly session. In fact, going back to when the General Assembly started looking at decriminalization, I often joked that these bills just had everyone seeing green. So once the proper license and regulatory structure is actually established for retail stores, so when commercial stores are given the green light in January of 2024, how are they going to be taxed? Well, in looking at the tax structure, they wanted to find a way to tax it to a high enough degree that it would generate plenty of revenue for a number of initiatives, but not tax it so high that you would be encouraging a secondary black market, or rather the continuation of a black market. So what the General Assembly landed on was that retail sales will be taxed at a rate of 21% statewide. This tax will apply to retail marijuana, marijuana products, marijuana paraphernalia sold at retail stores, and more. It doesn't apply to sales from one marijuana establishment to another, sales of cannabis oil for medical treatment, or the sales of industrial hemp, but it does apply to everything else. And as you'd expect, when it comes to a 21% statewide tax, it's already fully accounted for when it comes to what the revenue is going to go to. 40% is going to go to pre-kindergarten programs for at-risk 3-year-olds and 4-year-olds. 30% will go to the Cannabis Equity Reinvestment Fund. 25% will go to the Department of Behavioral Health and Developmental Services, or DBHDS, for community service boards. And then 5% will go to public health programs, including public awareness campaigns that are designed to prevent drug driving, discourage consumption from minors, and then inform the public of the potential health risks of marijuana usage. So very importantly, there is a local government piece to this. It's something that we worked really hard to include in the final version of this bill. On top of that statewide 21% tax that I just described, there is actually an optional local marijuana tax. So this is under section 4.1-1004, so section 4.1-1004, which allows any locality by ordinance to levy a 3% tax on any eligible sale. I'll note that this tax is considered in addition to any local sales tax, any local food and beverage tax, and any local meals tax. So it's really an important piece for local governments. While the revenue generated for that statewide 21% tax is already accounted for, the revenue generated by this optional 3% local tax will actually go directly back into local government coffers. If you're interested in looking at the more details about the timing of this, you can see more of it at section 4.1-614, where it further details how these taxes will be collected and how and when they'll be distributed. One last note I'll leave you on in this topic. If a town elects to impose a local option marijuana tax, and the county also imposes a 3% tax, that 3% tax from the county doesn't apply on top of the town's tax. Fairly intuitive. They just wanted to lay out in code that there can't be really any double dipping, so to speak.
Right. Beyond the tax and revenue, I know there were other debates this session about other areas of local government control. How did all this shake out in the final bill?
There were a lot of debates about that. You are absolutely right on that angle. And it really focused on a few key areas. The first I'll look at is the idea of a local option referendum. This probably is the most single asked question that I've gotten, and I think the rest of our staff has gotten in the last month, looking into this when our members are reaching out asking more. So the bill's patrons and the governor's office all really wanted to avoid a convoluted opt-in, opt-out process when it came to the overall question of whether or not to legalize simple possession of marijuana. So instead, they turned their gaze onto the question of, well, maybe we could look at opting in or opting out of retail stores in localities. Much as is the case with local government options for alcohol sales right now, this legislation essentially establishes a presumption that retail stores are permitted in any locality. The bills do, however, provide a very limited option for localities to opt out of their retail stores via a referendum. So under section 4.1-629, the governing body of a locality may, by resolution, petition the circuit court of their locality for a referendum on the question of whether or not retail stores should be prohibited in their locality. The referendum must be very simply worded. Shall the operation of retail marijuana stores be prohibited in fill in the blank of your locality? If a majority of the voters vote no to this question, retail stores shall be permitted to operate either 60 days after the referendum or January 1st, 2024, whichever is later. If these voters have voted no, so they do not want to prohibit retail stores, no subsequent referendum may be held pursuant to this section, period. So if the voters vote no to the question of whether or not to prohibit, that's the end of the line. If, however, a majority of voters vote yes in this referendum, the retail stores will be prohibited effective January 1st of the year following the referendum. A referendum on this question then may be held subsequently to the vote, but not until 4 years after. Now, while this yes or no kind of referendum approach may seem fairly cut and dry, there are two enactment clauses that really limit this option that I really want to highlight here. Enactment clause number 5 notes that the provisions of section 4.1-629 shall be effective on July 1, 2022. This delayed enactment clause means that no referendums may actually be held this year. So our local governments wishing to pursue this option are not going to be able to do so during this fall's election. And then there's enactment clause number 23, which notes that the initial referendum shall be held and results certified by December 31st, 2022. A referendum on this question shall not be permitted in a locality after January 1, 2023. So in simpler terms, what this enactment clause does is say that a locality interested in a referendum must hold and certify the vote by December 31st, 2022. And then no referendum on this subject may be permitted after 2023. So if you've got your calendars out at home or kind of thinking through this timeline, you'll realize that this window really has narrowed. You know, the effect of these two enactment clauses is that if you want to have a referendum, you must hold and certify the results of the referendum between July 1, 2022 and December 31st, 2022.
Chris, outside of this referendum, is there anything local governments have power over? Is there anything additional they can do to control or deal with the retail marijuana stores?
So the governor's office and the administration, as well as the bill's patrons and frankly the stakeholders all pushing for and supporting this bill, all made it very clear during the drafting and advocating process that they wanted to avoid the redlining or possible redlining of retail stores. So as such, they did limit what local governments could really do when it came to retail stores. So under section 4.1-630, subsection A, the legislation stipulates that no county, city, or town may adopt any ordinance or resolution that regulates or prohibits the cultivation, manufacture, possession, sale, distribution, etc. of retail marijuana or retail marijuana products. So while that's fairly cut and dry, the rest of this section in 4.1-630, it does afford some tools to local governments that I think are important to note. Subsection B permits a locality to adopt an ordinance that, one, prohibits and penalizes the consumption of or offering of marijuana or marijuana products in another public place, or two, that prohibits the possession or consumption of marijuana on public school grounds. And then finally, in subsection C, a section that we fought really hard to get included, the legislation stipulates that, quote, nothing in this chapter shall be construed to supersede or limit the authority of a locality to adopt and enforce local ordinances to regulate businesses licensed pursuant to this chapter. This includes local zoning and land use requirements and business license requirements. And then finally, in the very next section, section 4.1-631, the legislation does empower localities to adopt ordinances regarding the time and sale of retail marijuana and retail marijuana products. Now, how this is all going to play out, it's a great question. As I say, it's really no simple highway for us. How this will mesh with the forthcoming regulations from the Cannabis Control Authority, it's also a great question. This is something that we here at VACo, as well as our other local government partners, will be watching very, very closely in the coming weeks, months, and years.
Chris, over the last few weeks, and I know you've heard this too, we've heard that there's a lot of confusion out there about driving under the influence and the open container policies that we have in the Commonwealth. Can you address that in just a minute?
Absolutely. Open container laws and under the influence laws are really one of the biggest question marks or murky areas that remain under this new legislation. You know, while it would be great to say that this new policy or the new policies in this legislation are simply analogous to the current alcohol related under the influence or open container laws, unfortunately, it's just not that easy. Under section 4.1-1107 of this new law, it notes that it is unlawful for any person to use or consume marijuana or any marijuana products while driving or being a passenger in a motor vehicle upon a public highway in the Commonwealth. Now, unlike alcohol, you can't simply perform a breathalyzer test or even an effective blood test to see if a driver or passenger was under the influence at the time of their traffic violation. So to address this and ensure that law enforcement can still enforce their under the influence laws, the legislation actually creates a presumption that an individual has consumed marijuana and therefore is under the influence if there is an open container found in the passenger area of the vehicle. So what does the open container even mean when it comes to marijuana products? The legislation defines open container as any vessel containing marijuana except the originally sealed manufacturer's container. Well, here's where it gets more complicated. This policy was really drafted with legalized retail in mind. So it was really drafted with its eyes looking towards 2024. It wasn't really drafted intentionally for this July 1, 2021 legalization, but rather to work within the confines once there are actual legal stores out there. So while personal possession of marijuana will be legalized this year, retail is not until 2024. So we've got 3 years before we're going to actually be able to purchase marijuana from a licensed retailer or manufacturer. So when it comes to this open container law, unless you've procured marijuana from a licensed retailer outside of Virginia and brought it back, which I'll note the legislation still clarifies is illegal, you're not going to have sealed manufacturer's containers. So that also means that you'd be caught under this presumption of use if you're simply transporting the products you grew yourself on your legal plants. So legalization advocates, industry advocates, and even state legislators have already all noted the imperfections of this section. You can see it pretty consistently in every big write-up that we've seen in the newspapers about this. And this will definitely be one of the facets of the legislation that will continue to be worked on by the legislature, not just in anticipation of 2024, but really probably next session we'll see tweaks to this law. In the meantime, the governor has included funding to try to help work with local law enforcement and fund local law enforcement to better work with this policy.
Chris, what can you tell us about employment issues related to marijuana use?
That's another great question, and something I think will, much like the open container laws, see a lot of continued discussion and debate about over the next several months and years. I'll start by just reminding the viewers or listeners that despite Virginia's move to legalize simple possession of marijuana, it does still remain illegal at the federal level. So for those that hold federal jobs, security clearances, etc., marijuana usage is still grounds for losing those clearances and those jobs. Beyond this, however, I'll note that honestly, this legislation does not do much in the way of limiting an employer's ability to maintain employment policies that disallow drug use on the job or require employees to continually pass drug screenings. Think of safety-related jobs, law enforcement positions, medical jobs, government jobs, etc. There's nothing in these bills that eliminate the right of an employer to require employees not to be impaired on the job or pass a drug test. Furthermore, much like an employer may disallow the possession or use of alcohol on its premises, there's nothing to say in this legislation that employers can't establish similar prohibitions regarding marijuana. Now, I'll briefly note that there was another bill from this session that's been signed into law, Delegate Helmer's HB 1862, that does prohibit an employer from discharging, disciplining, or discriminating against an employee for their use of cannabis oil for medical reasons. But those are medical reasons, and that doesn't really extend into the recreational marijuana realm that we're actually talking about today.
What about past marijuana use, Chris, or actual legal charges or convictions? Does this bill do anything about those charges?
It sure does. As I mentioned earlier, the criminal justice piece of this bill, the criminal justice reform portions of this bill really are enormous and sweeping in nature. We could spend an entire webinar talking about this. We could spend an entire day dissecting this. But for now, I'll just note that the bill does provide automatic expungement and sealing of past misdemeanor convictions. So you can find details about this automatic expungement process in section 19.2-392.1:1. There's also a process laid out for people convicted of more serious or more severe marijuana-related offenses, so the non-misdemeanor convictions. And they don't have an automatic expungement process or an automatic sealing of records process, but the bill does establish a process in which they can petition for expungement. That can be found in section 19.2-392.1:2.
What comes next?
Well, Dean, we're going to have to see what tomorrow brings. Simple possession as well as home growing is legalized beginning July 1, 2021. So in just about 70 some days. After that, the Cannabis Control Authority will be established. New rules and regulations for retail stores will be developed. But over the next several years, and indeed the next several months, and pretty much every day from now until January of 2024, you can expect further study, further analysis, continued tweaks to these bills, cleanups of these bills, more questions answered, and if we're honest, a lot more questions will probably be continued to be raised. I'll be monitoring developments every step of the way, as will our local government allies. It's a brave new world we're stepping into, and it's going to take some figuring out. It's going to be very interesting times ahead.
Chris McDonald, thank you for being with us on the VACo County Pulse, and we look forward to talking about more legislative issues in the coming weeks. Thank you.
Dean, thanks for having me. Thanks, everybody.